Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a warm hello to everyone in between. My name is Dan Balkaran, and I am going to be your employment lawyer for the next 30 minutes. You can see my name on the screen. That's Dan Balkaran, and I'm an employment lawyer at Samfiru, Tumarkin, LLP. Samfiru Tumarkin is Canada's leading employee-side employment law firm. So let's see if we got some questions coming in. Just making sure I have them all. Okay, so I'll tackle your questions. Yeah, no, they're starting to roll in. Okay, I'll tackle your questions. There's been lots of sort of grim employment news in the news lately. A lot of layoffs happening as the economy starts to go through a bit of a dip. And certainly happy to talk about those things. But let's see what the questions are first. So from Heather, how is severance calculated if employees been off work on medical leave for more than 12 weeks prior to the termination? So you're still an employee while you're on medical leave. There's no interruption in service. At least that's the way I've always done it. And therefore your severance is calculated. I mean, are you talking about employment standard severance, or are you talking about common law severance? So if you're talking about employment standards severance, which I think it might be, or you might be, sorry. If you're talking about Employment Standards Act notice or pay in lieu, it's generally calculated based on your last 8 weeks of work. So I would assume in BC, called the Employment Standards Branch, would evaluate the last 8 weeks that you worked and then take an average of that, and that's how much you'd be paid for your statutory minimums. But if there's, sometimes there can be, depending on how your pay is calculated, it can be like spikes in commission that do weird things, or dips in commission that are outliers that can do weird things for the actual amount of Employment Standards Act severance you're to receive. And so in situations like that, I certainly know, and I don't know about the various employment standards bureaus in the rest of the country, but in BC, certainly they'll take a 6-month snapshot and do an average. So if I think that's what you're probably referring to, if you're referring to common law severance, which is the bigger severance, which is can be as much as 24 months, depending on your what your employment contract says and your age, length of service, and position, then I don't, generally speaking, a leave is a leave, but you're still an employee, and therefore, I have not calculated it as part of a reduction in your length of service. Maybe if you're on a medical leave for 2 years, that might be different, but certainly not for 12 weeks, I don't think. So, listen, if you've been terminated immediately following a medical leave, or while you're on medical leave, you should talk to an employment lawyer right away. You might have a human rights complaint to pair with your severance claim. You might have a significant claim to both the severance or to human rights damages. So I strongly recommend, Heather, you speak to an employment lawyer. If you need to get a hold of us, you can always do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, Sandy asks, is it okay to go on medical leave while preparing a constructive dismissal case? Note that spouse works in the same place, is on medical leave currently, and is also working on a constructive dismissal. Well, okay. So there's a lot going on there, Sandy. Let me just talk about some of those things. So there are lots of situations where spouses work at the same employer and the relationship sours with one employee, but not necessarily the other one. And so depending on how aggressive a position you take, that leaves your spouse in a situation where maybe the employer is not very pleased with the both of you. Okay, it's hard for employers to separate the two of you out, and so most families can't survive losing two incomes at the same time. So that's just something. It's not a legal evaluation. It's just something I've found over and over again. You need to tread carefully when both of you work at the same workplace. If you're both counting, if you can't afford to lose the income at the same time. Now, you're both on medical leave and both preparing constructive dismissal. I will also say that is I have some concerns about that. Okay, so for you, constructive dismissal is it's difficult to make out in some circumstances. So it's worth discussing what constructive dismissal is here for a second. So in order to get severance, your only legal right actually flows from your termination effectively for most of you. So if you are terminated without cause, you get severance. Now, if you're depending on what your employment contract says, you might be limited to the Employment Standards Act minimums, which are small, roughly 1 week per year of service to 8 weeks, or common law severance, which is much bigger, can be as much as 24 months, depending upon your age, length of service, and your position. And so, assuming you get common law severance, when you lose your job without cause, that just simply means they don't have a valid reason to pay you zero, such as stealing. Then the evaluation goes, you're terminated. How much severance do you get? How have you made reasonable efforts, or have your efforts to look for replacement employment not been unreasonable? And then there's just a sort of a quantum assessment of all of that. And out comes a number at the other side for your severance measured in months. Constructive dismissal adds another piece to that. It's, does a judge think that the actions of the employer were a de facto termination? If so, how much severance do you get? And were your efforts to look for replacement employment reasonable? If you lose on the first step, you get zero because you quit. Okay. And so constructive dismissal comes in effectively two forms, where the employer breaches a fundamental term of the employment contract such that you have been terminated, or where the employer, through its actions, has effectively repudiated the employment contract. So it's sort of like a death by 1,000 cuts kind of thing. So looking at the first one, the classic way to get there is your wage has been cut by 25%. It's a different contract that you're working under, therefore you have been effectively terminated. That is the easiest way to get to constructive dismissal. But it doesn't have to be wage. It can be a fundamental term, but it's important that it be fundamental. So wage cut by 25%, hours cut by 25%, equaling effectively a decline in pay by 25%. Gets a little trickier when you get into demotions. So you've been demoted. You were the senior manager of customer service, and now you're just a customer service representative, that kind of thing. Or if your position, your wage is the hardest. Wage and hours haven't been hollowed out, or wage and title haven't been changed, but your position has been hollowed out, and therefore you have de facto been demoted, even though your money hasn't changed. Those kind of things are a fundamental breach by the employer in terms of your employment contract. The other way to get there is even harder, and that's where the actions of the employer indicate that they just don't want to employ you anymore. And so, that's ongoing, well-documented harassment, constant little changes to undermine your quality of life at work, or some of the terms of your employment. And all of those things serve to indicate that the employer doesn't want you there. It's very hard to get there on that second branch. And so the underlying animus of employment law is, it's to redress the imbalance of power between the employer and employee, because the employee has very little power as against the employer in almost all cases. But it tends to be informed to a great degree by policy considerations, and certainly full employment, or it tends to, the core principle is it's not compensatory. Yes, severance appears to be compensatory, but it's really your entitlement is not to severance, it's to notice. It's a heads up that you're going to be terminated in the future to cushion your landing when you lose your job, and therefore financially, and therefore it's the animating principle for judges tends to be full employment. And so here you have to get a judge to say, there's no way you can work there anymore. If I was in your position, I couldn't work there anymore. And so with constructive dismissals, it has to either be a fundamental term or it's completely unreasonable for you to continue in working there, given the behavior of the employer. And if it's the second one, you better have a lot of evidence. And so when you tell me, Sandy, that you've got two of you both on medical leave who are husband and wife, both claiming constructive dismissal, I get concerned, because it's very difficult for the same broad strokes pattern to happen to two people who are married at the same time in the same employer. Now, I'm not saying that isn't what's happening, but I think, Sandy, you 100% need to talk to an employment lawyer and go over all of this. You both do, and probably the same employment lawyer, and just assess the strengths and weaknesses of your case. Because, if you get constructive dismissal wrong, you quit, and you could end up owing money at the end. So of everyone I talked to today, I encourage you to, or all the questions I answer, I absolutely encourage you to talk to an employment lawyer. You can reach us, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. To answer your question specifically, to go on medical leave, is it okay to go on medical leave while preparing a constructive dismissal case? Well, lots of people do that, right? Lots of people go on medical leave because, stress leave, because they can't take what's happening anymore. And fair enough, you've got to follow the advice of your medical doctor. Just make sure it's properly papered. Send that information in to your employer. Do it by email that you control, not your work email, so that you have copies and a paper trail of you submitting your medical notes. Make sure that you refresh your medical notes every time the time period on the medical note expires. So if their doctor says Sandy's got to be off work for 2 weeks due to medical concerns, you better get a new doctor's note by the end of that 2 weeks. Otherwise, there's this risk that you have abandoned your position. I mean, it's a lot harder to get to abandon your position, but you get the idea. So cover it. Make sure you're covered, properly papered. Make sure you're properly papered at all times from your medical doctor, and so there's no risk of you abandoning your position. And then, if you're going to pull the trigger in constructive dismissal while you're on medical leave, I mean, certainly I've done that for clients. It's somewhat tricky, but I would, in terms of the timing and how you do it, I would 100% talk to an employment lawyer. It's almost impossible for me to advise you sort of generically like this over a one paragraph question. So I really encourage you, Sandy, to talk to an employment lawyer. Okay. I'm not going to say this person's name because I think it identifies them. We'll call them B. It's first initial. My company fired me for misconduct and used a write-up from 3 years ago to say they had cause. Is there anything I can do, or do I have to accept a for-cause termination? Yeah, I mean, listen, so they're firing you on the basis of progressive discipline, most likely. There are two broad strokes ways to get to just cause, and I'll just back up here a second. The purpose of severance is to tide you over until you get your next job. Okay, it's to cushion your economic fall from losing your job. And it's really a public policy thing, because we can't have people sort of thrown out in the street with no money and no job, and so it cushions your landing. That's what it's for. So the law wants you to get severance, but there are rare exceptions where the conduct of the employee justifies no severance. That's called just cause. Now, there are two broad strokes ways to get to just cause, as I said. Single act by you, the employee, that is so egregious the employer is justified in no longer continuing the employment relationship. That would be theft, fraud, committing an indictable offense, punching your boss in the face, coming to work high on drugs, these type of things, intoxication at work. I mean, and even some of those won't get you there. But you get the idea. It's serious event. 1 time, 2 times can get you there. The other is a series of ongoing performance failures, conduct failures, that you've been provided clear warning of and an opportunity to correct. So that's your classic 3 written warnings and you're out. Now, if your employer provided you a warning 3 years ago and then fired you today based on that one single warning, that's not, in most cases, going to be cause. You haven't been providing clear warning that you're going to lose your job, and they should have told you, hey, we're going to fire you if this continues. And maybe they did that 3 years ago, but there's no immediate pattern of continuance. But I would say that's counterweighted by the degree of seriousness of what you did, right? There's that famous case in British Columbia a few years ago where the employee, or he worked for a winery, and the employee accidentally spilled like 26,000 gallons of wine or something that would cost the company millions of dollars or hundreds of thousands of dollars. And it was the second time he did it. And they were separated in time, but he was terminated for cause. And I believe it was upheld. I can't remember the exact result, but I believe that was cause in that case, right? So it depends on the seriousness of what you're talking about. But no, I think you should talk to an employment lawyer. I sound like a broken record today, but most likely, if it's one write-up 3 years ago, no, it's not going to be cause, or you're going to have a good claim to severance, depending on what your employment contract says. You might have a good claim to common law severance, and you should 100% talk to an employment lawyer. And if you want to do that, if you want to talk to us, you can do so at employmentlawyer.ca, as you see on the screen, at help@employmentlawyer.ca, and 1-855-821-5900. Okay. Labor Canada said I should reply to a salary reduction letter along the lines with, I don't agree with the decision. Can you suggest wording will take effect August 8th? Okay, Sandy. So this is Sandy again with his constructive dismissal. I don't think you should be taking legal advice about constructive dismissal from a sort of a generic tribunal who's not a lawyer. I mean, they might have lawyers working there, but it's not their core job to advise you on this kind of thing. But generally speaking, they're correct. You want to reject the reduction. You have, just so you understand, with a constructive dismissal, you have about 2 months to try on the reduction before you're deemed to have accepted it. So if you work under this reduced salary for 4 or 5 months, then you try to reject it, too bad, you're out of luck. You have now accepted the reduction. So you have to move fairly quickly. So yes, you have to object to it. I'd work under the reduced pay for a week or two, probably get one paycheck, and then I would pull the trigger on it and say, no, your reduction is constructively terminated by employment. However, you got to be very clear about a couple of things. Number one, is this pay reduction temporary? If this is a situation where they reduce your pay for 3 months and then it's going to go back to normal, you're not going to win on a constructive dismissal case. And second of all, if it's a small reduction, sub 10%, probably also not going to win, right? And is it fully pay, or is it a mixture of pay and taxable benefits? So I really think that you should speak to an employment lawyer about this again, and I'll repeat it again for everybody. Employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Sandy, you got to talk to a lawyer. 100% you got to talk to. Constructive dismissals are hard. Just for anybody on here, if you're thinking about claiming a constructive dismissal, don't pull the trigger on it until you talk to an employment lawyer. It is 100% worth it. If you get it wrong, you quit and you got nothing. So absolutely talk to an employment lawyer, Sandy. And okay, there you go. Sandy says wage cut is 12%. Well, that's sort of right on the line. Different provinces say different things. There's a famous, I think it's a Court of Appeal case in BC that says, I think it says 9 to 10%, not a constructive dismissal. Above that, it doesn't say. Implication is it is, but there have been lots of cases that find very little as a constructive dismissal. It all depends on the context of your circumstances. So, for example, if you're making $350,000 a year, is a 12% pay cut a constructive dismissal? Probably not. You're still making lots of money. But if you're making $35,000 a year, would it be? Yeah, probably. Right? It all depends on the circumstances, and it's not just wage. It's the circumstances that have everything to do with your employment. Maybe you have a situation at home where that they're aware of with dependents that you can't afford the pay cut. And I just, Sandy, since we're talking so much about constructive dismissal today, I do want to say one thing. You have to understand, when you pull the trigger in your constructive dismissal, when your lawyer says, my client considers your 12% pay cut to be a constructive termination of his employment or her employment, you don't work there anymore. It's done. It's over. No more paychecks. Okay. And then you've got to try to explain to EI how you were constructively dismissed, because your employer is going to say you quit. You don't get EI if you quit, and you've got to be prepared financially for that. It's not it's a serious thing, and you need to make sure that the potential payday at the end of that process is worth it to cut your wage. Like if you're talking about, you have a best day of about $45,000. I mean, unless you're going to quit anyway, it's probably not worth it. If you are going to quit anyway, sure, then pull the trigger on your constructive dismissal. But it's well, let me rephrase that. You have to be financially prepared for the fact that you're not going to have a job the moment you pull the trigger on your constructive dismissal. That's what I'll say. Okay. So it's a serious thing. So just be aware of that. Ashley says, my partner works outdoors in a construction job. Can his employer force him to work if there are air quality warnings due to smoke? Interesting. I think the correct thing to do there is to get a doctor's note. If you have a doctor's note, and in all situations where medical anything is implied, if your doctor agrees that you can't be working, then get it. The question then becomes, can you go on? If you don't have a health issue that instantiates in you, like I'm not saying you don't, like let's just say you have minor emphysema or something like that, and you're normally fine, but it's the arrival of smoke where you are that precludes you from working. Can you get medical EI, or can you get short-term or long-term disability through your insurance company should you have insurance? I don't know the answer to that question. I've never even considered it before. I could see them saying no, right? It's not like you fell and broke your arm and can't work. It's that something changed in the environment around you on a temporary basis. I don't know. You'd have to ask Service Canada if you can get medical EI. But my point is, Ashley, I think that if you get a doctor's note saying no, your partner can't work, I think the employer is going to have to abide by that while there's smoke in the air, because we don't, who knows what your partner's health situation is. If you don't get the doctor's note, though, I don't think there's anything you can do. I think you have the choice of quitting or continuing to work there. But if you do get the doctor's note, I think you're probably fine. But the question is, can you get paid during that period of time? And if EI won't provide you, Service Canada won't provide you with medical EI, and your LTD and or STD, short-term disability providers, won't provide you any pay because they don't recognize that as a disability, you have to be prepared to work without getting any money, right? So you'd be not getting paid. So something to think about. And before I pulled the trigger on the medical note thing, I mean, listen, I don't know what your medical situation is, and so if this is something where your partner just absolutely cannot work in the smoke, and that's the only concern, but you want to preserve your job, then yeah, go get a medical note, and you'll have to deal with potentially not making any income during that period. But if it's sort of an on the fence thing, I would talk to Service Canada. You might be on hold for 2 hours, unfortunately, but I'd talk to Service Canada, find out if you qualify for medical EI under those circumstances. If you have a medical note, look into what your insurance provider says, and then make your decision. Sam says, or asks, if you work at the same company as your spouse, can your employer force you to work in different departments? Yeah, I mean, well, okay. So let me tackle that question a little differently. If you've worked in Department A for a long time, and then your spouse comes in Department A, and then the employer says, we don't like this, we're going to make one of you move. Could the move be a constructive dismissal? Yeah, it depends on the circumstances, right? Like as long as your pay and title don't change, or but if your duties are going to change, most likely when you move departments, then is the change of duties a hollowing out of your position in prestige? You were working in as customer service supervisor, and now you're the janitor or something. But listen, hollowing out of duties becoming a constructive dismissal, or a changing of your duties being constructive dismissal, very difficult to make out, notoriously difficult to make out in BC. So, I mean, yes, and certainly I've had my share of clients in that situation, but you if you got to make sure that's worth it, you got to understand you're going to take a severance discount for that, and you cannot make any sort of you can't pull the trigger on a constructive dismissal. It's constructive dismissal day. I don't know why it is, but it is right now. You can't pull your trigger on that without getting advice all the way through from an employment lawyer. Okay, you can't. That's not something you can do on your own. Now, that I know that wasn't your question, but really, that's your remedy if you want to force the issue. Remember, you've got 2 months from the date of the move, effectively, to claim constructive dismissal. You shouldn't claim it though, or even reject the move, I think, without talking to an employment lawyer. You got to make sure you do that before the 2-month mark. If you need to get a hold of us, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. But backing up to your core question, can they force you to move to work in a different department? Your employer can do anything it wants within reason. And I as an employment, let's just say I was your employment lawyer, I have no way to stop them from doing that. The only thing you've got is, in the event of your termination, then do you have a severance claim? Or can you, after they've moved you to a different department, can you claim constructive dismissal? I mean, technically, you might be able to get a lawyer to. So it's a post hoc remedy. It's after the event has happened. You can get a remedy which would result in you leaving the employer and hopefully getting money. But that's a lot of times money is a poor substitute for your job, particularly if your spouse works there. But there's no means to prevent them from doing that, other than I would almost never recommend this. I've done it a couple times, but what you could do is you could get a lawyer like me to write you a letter before you're moved saying we're going to treat this as a constructive dismissal. It's a very dangerous thing to do. It's a constructive dismissal if you move them, or I mean, maybe wouldn't threaten them outright, but just say, remind you that this is probably a constructive dismissal, and this is what Sam's severance claim would be, and this is what the worst day outcome is for the business. Sam would prefer to remain in his department. Almost never do that, because once a lawyer writes a letter, the well is pretty much poisoned. It's very hard to continue to work there after your lawyer has sent a fairly aggressive email or letter to your employer. So, but no, there's no means that you have to force to prevent them from doing that. Your remedies are all after the fact. Sandy's back. Same issue as Sam's post above. Seems like a human rights discrimination based on marital status. Have been verbally told 3 times they don't want a married couple working in the same department. Okay. So you're saying that's a constructive dismissal because they want to separate you into different departments. Again, that depends on the materiality of the change in your pay or duties or hours, right? So you'd have to have an employment lawyer really review that. Is it discrimination based on family status because they said they don't want a husband and wife working in the same department? No, I don't think so. I no, because they're not asking you to do too much. They're just moving you to a different department. Is that a little strange of the employer? Maybe in today's day and age, but each employer is different about those things. I worked for an employer once that was very clear. There could be no fraternizing between employees, and others where it happens all the time. And when something serious materializes, it's celebrated. So, yeah. I mean, no, I don't think that's discrimination. I think if they hollow out your position or reduce your wages based on separating the two of you, then I think it could be a termination. Constructive termination, but I'd be really careful with that, Sandy, and you should 100% talk to an employment lawyer. Marilyn, can my employer change my position and pay if I'm still on probation? Well, I mean, yeah, and if it depends on what's your employment contract anyway. If your employment contract says they can do that and it doesn't affect your employment contract, the terms of your employment contract, they can do that anytime. But if you're on probation, you got to remember what's your remedy, right? In all, like with everything, it's if something happens, what's the remedy? And in your case, you're on probation. You effectively either, depending on how long your probation is, you probably have zero remedy because there's no severance in the first 3 months of probation, or your remedy is very, very small. So, and if it's a suitability thing, unlikely anyway. We're almost done. I know we're out of time, but let me just finish these last two questions. How many times can a fixed term contract be renewed? It's a great question. So fixed term contract can be renewed effectively 3 times, more or less. I'm not going to give you exact, precise answers because employment law is not about that. It's about probabilities. But 3 times before you become an indefinite employee. However, just be aware, sometimes if you're terminated, you actually want the remainder of the fixed term contract. If you get terminated 3 months into a 24-month fixed term contract, you don't want common law severance of a few months. If you've only been there for a few years, you want the 21 months remaining on the fixed term contract. But yes, generally speaking, 3 times before you become an indefinite employee. But I wouldn't necessarily play that card. I wouldn't tell the employer that you are in fact now an indefinite employee. Let them think whatever they want to think, and if you need to play that card later, do that, and make sure you have the advice of an employment lawyer when you do it. Sandy replied with just thanking me for the answers. Lots going on at work, not a pleasant environment. Salary is not everything. Yeah, so that last piece there, no, it's not. And so the law has repeatedly said that it isn't only about your wage, and that employees famously derive personal satisfaction from employment that is greater than just their wage, and so that is sort of the animating principle behind why a demotion can be, or a hollowing out your duties can be, a constructive dismissal. It's because of that loss of sort of personal dignity wrapped up with what your job is. With that said, it's very hard to make those out in Canada and certainly in British Columbia. So, okay, guys, thank you. Or okay, everyone, thank you for the great questions. Those were really great. It was constructive dismissal day. I wish you all the best of luck. If you need to, with those, if you need to get a hold of us, you always can at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Thanks, Tanya. And you join us again, 1:30 Eastern Time, June 12th, Monday. Chris Justice, explaining all things employment law. I will be back in 2 weeks, my regular time slot. As always, I'm Dan Balkaran, your employment lawyer at Samfiru Tumarkin LLP, and I wish you a safe and wonderful weekend.